The court now begins the final round in the case concerning the Rotian Union. I invite the first oralist on the applicant's side. Now you may begin.
May it please this court, I'm Karthikeya Tanna, agent for the applicant state of Adarea, and I shall be presenting my propositions on submissions A and D, contained in paragraph 41 of the compromise, over the next 21 minutes. And my co-agent, Mr. Kadri Rashid, shall spend the same amount of time in presenting his propositions on submissions B and C. And this leaves us 3 minutes for our rebuttal. Firstly, moving on to submission A, the respondents have violated international legal obligation owed to Adarea by denying it membership into the Rotian Union. We present 3 propositions. Firstly, it is the 5 member states comprising the Rotian Union that are responsible for the breach of the international legal obligation contained in the Adarian accession agreement, and not the Rotian Union. Our second proposition is that the international obligation owed to Adarea is to consider it for membership once it becomes eligible on satisfaction of the 3 conditions mentioned in the AAA in accordance with the principles of good faith. Our third proposition is that Adarea has been denied membership on a clear lack of good faith, and is therefore there has been a breach of international legal obligation owed to Adarea. Moving on to our first proposition. It is submitted that the Rotian Union does not possess international legal personality vis-à-vis Adarea. Now there are... Indeed, Your Excellency.
In your brief for the court, you have extensively tried to argue that the Rotian Union has no objective international personality, as you call it. I was very pleased to see that old expression from literature come back here from the cases before this court. I wanted to ask you, it is true that according to the facts, Adarea is one of the founding members of the WTO, isn't it?
Indeed.
It is also true that in 1997, the Rotian Union acceded to the WTO. Now, what conclusion is the court to draw from that? Haven't you accepted that the Rotian Union has an international personality even vis-à-vis you, because you have been both members of this organization, and certainly during the negotiations for the accession of the Rotian Union, you have had negotiations with them on their commitments upon entry in the WTO. What is your views?
Indeed, Your Excellency. There are 2 answers to Your Excellency's question. First of all, regarding the membership in the WTO. Article 12 of the Marrakesh Agreement establishing the World Trade Organization says that any state or customs union's territory possessing autonomy in its external commercial relations may join the World Trade Organization. And the second paragraph says that it's a decision of the 2/3 of the members of the WTO when a state will accede to the World Trade Organization. Now, we submit that the Rotian Union might have legal personality, but it does not have international legal personality vis-à-vis Adarea. It may have international...
Why then didn't you avail yourself of your possibilities under Article 13 of the agreement that you just cited, which speaks about the non-application, the possibility of creating a situation of non-application between you and any new member state that exceeds?
We submit that the agreement that, and this is the second answer to Your Excellency's question, the agreement in the present case, the treaty that's in force, is the Adarian accession agreement. We have entered into the treaty with the Council of the Rotian Union, and we submit the Council is a body of the Rotian Union that consists of the heads of representatives of the member states.
It's not an answer to my question. I was referring to Article 13 of the agreement establishing the WTO, which gives you the possibility to exclude relations with the new member with which you want to have no interaction, of which you otherwise do not recognize.
Indeed, Your Excellency, Adarea hasn't had any commercial relations with the World Trade Organization. This is the first time Adarea is into relations with the Council of the Rotian Union for the purposes of getting into an organization called the Rotian Union. We haven't had any relations from the facts of the compromise with the Rotian Union in terms of the commercial relations. And therefore we submit that this does not apply to us, and Adarea is not acknowledged to recognize legal personality of the Rotian Union.
May I follow up on that, Council, in terms of the W2 membership? But what about the bilateral agreement between the Republic of Bulgaria and the Council of the Russian Union? Are you saying that that's not a treaty, but because the Russian Union has no international legal personality? Or are you saying that the Council of the Union has international legal personality? Or are you saying that your state is not bound by this agreement because the other side doesn't have international legal personality?
Indeed, Your Excellency, we submit that the treaty is in force and we are bound by the treaty. However, the party to the treaty is the Council of the Russian Union. Now, the Council consists of the heads of state of the respondent states or their representatives. Furthermore, this particular act, which is the nature of the act that is to be taken into account in determining whether or not a decision like the Council decision is a decision of the Council as the Russian Union organ or as the member states sitting together, is very important. We submit that this is the decision of an accession of a new member state, of new state into the Russian Union. Now, when a state wishes to join the treaty establishing the Russian Union, this is effectively brought about by amending the treaty establishing the Russian Union, because Adria joins as a high contracting party to the Russian Union. Now, it is.
Do you have any indications for that in the treaty establishing the Russian Union, that that is really an amendment to the Russian Union treaty?
We submit that the treaty establishing the Russian Union begins with the name of the 5 states that are currently parties to the treaty. Furthermore, Article 1 says that the high contracting parties agree to bind themselves by an organization called the Russian Union. Because Adria would join the Russian Union, it would become a high contracting party to this treaty, and therefore this is an amendment of a treaty, and it is only logically possible that the member states have retained their competence in the field of an accession agreement, and they are the ones who decide on whether or not Adria joins the Russian Union. This is further reinforced by the fact that the Council not only concludes the AAA, but also approves the membership application by a unanimous vote, which means all 5 member states unanimously vote if Adria is to join the Russian Union. These factors taken together and the nature of the very act, which is the accession of a state, reinforces the conclusion that this agreement has been entered into with the member states, the councils representing the member states and not the Russian Union.
Then why does it consistently throughout talk about the Union?
Because this,
to facilitate successful integration of Daria into the RU, and particularly in 3, RU representative office, RU delegation, shall serve as the official representative of the RU.
Indeed, when an organization is brought into force, it never happens that all competence is offered to the organization or all competence is retained by the member states. Some competences are offered to the organization and some competences are retained by the member states. Now, we submit that in this case, in the case of an accession agreement, the facts of the compromise are uncertain about it. However, the nature of the very act of accession shows that this is a decision of the member states sitting together. Indeed, the treaty establishing the Russian Union does mention about the Russian Union thereafter, but this is a treaty that concerns Adria's entry into an organization, a supranational organization called the Russian Union.
If you were
Given the time factor, you may proceed further, but in order to sum up the discussion, I would like to ask you, by way of a conclusion, your position. I just want to clarify your position. Are you saying that the Russian Union has no international personality at all, or are you saying that for the purpose of this case, the international personality of the Russian Union cannot be recognized?
It is the latter, Your Excellency. The Russian Union does not have international legal personality vis-a-vis Adria.
Okay.
And
So
Adria has, indeed.
now you can proceed further.
Indeed. We submit that nevertheless, even if the decision of the Council is regarded as a decision of the Russian Union, we submit that in the alternative, the respondent states are nevertheless liable for the decision of the Council in denying Adria membership. This is because the organization acting through its organ, Council, has acted as an agent on behalf of the member states. Furthermore, in the Senate Alliance case brought before the European Court of Human Rights against the then 15 EC member states, the International Court of Justice was asked to give an opinion whether the 15 member states are liable for the decision that was taken by the Commission of the European Union. And the ICJ clearly stated that the court should accept the possibility of member state responsibility for the conduct of organs of international organizations of which they are members. The states should not be allowed to escape their obligations by transferring power to international organizations, and furthermore, this view was in general conformity with the principles of public international law. Furthermore, in addition to this dicta of the International Court of Justice and its opinion, we submit that in this case, considering the relations and considering the constituent elements of the Council has acted as an agent on behalf of the member states and has denied membership. This agency argument has been recognized in Article 5 of the resolution adopted by the Institute of International Law in its 5th Commission report in 1995, which clearly states that member states will be liable if the organization has acted as an agent on behalf of those states, either in law.
Excuse me, it may well clearly state that, but what does that institute have to do with either established international law, customary international law, or treaty law? Why should we pay attention to what they said?
We submit that the Institute of International Law considers the limited jurisprudence that is available in international law and even opinions from states in considering in drafting this article. For example, the decision of the Arbitration Tribunal in the Westland Helicopters case, and even the International Tin Council cases in the UK House of Lords, and even opinions that were obtained from, unfortunately, only a handful of states. In line of all these decisions and the opinions, they have concluded that the member states will be liable if the organization has acted as an agent on behalf of the member states, and therefore...
Are you not assuming there is a breach of an obligation?
Indeed, which we turn to now.
And where will you come to now?
Indeed.
Great.
The international obligation...
And why should we? Because you shifted the argument or the basis for your argument from what the ILA had decided to the case law they had cited. But this is case law of national courts. And to what extent should we pay any attention to this case law from international courts?
We submit that this is a subsidiary source of international law under Article 38(1)(d), and we submit that there's a limited jurisprudence that's available in this area. Unfortunately, this is a situation that's arisen in a very limited number of times, and therefore we submit that this is a situation that is currently in international law and should be taken by this court. Now we move on to the international legal obligation. The international legal obligation is...
Wait a minute. Just on that particular
Indeed.
point. Again, by way of a conclusion, what you are suggesting is that what you have quoted as authority is simply a persuasive authority, not something which has an authoritative power to the conclusion that you are getting at. Is that a fair conclusion that I can draw from that?
Indeed, we submit that limited jurisprudence that's available indicates that member states can be liable for the acts of the organization.
Please proceed.
Turning to the scope of the international legal obligation, the scope of the international legal obligation is reflected in Article 11.6 of the treaty establishing the Rotian Union, where it is to consider ADERA for membership and it may approve by unanimous vote. Indeed, there is a discretion that's afforded to the Council. However, the consideration of the application is to be exercised in good faith, because good faith underlies the performance of every treaty obligation. Now, we submit that this international obligation has not been exercised in good faith. There's no fixed definition of good faith that's followed in the jurisprudence of the ICJ. However, 4 cases mention that good faith encompasses within itself the concept of normative acquiescence or estoppel by silence. Now, in this case, we submit that first of all, in 2001, there was a debate held in the Rotian Union Parliament where strong concerns were expressed for inclusion of the protection of the Sofian minority in the final draft of the AAA. However, the Council, in spite of being strongly urged by the Parliament, did not reflect that condition in the final draft of the AAA. Furthermore...
But could one not also say that that would have put your country on notice that that perhaps would be a consideration at a later stage? I mean, it's not nothing that a parliament which is directly elected in an international organization, which doesn't happen that often in the constitutions of international organizations, put forward concerns so strongly. So weren't you put on notice that that might be a consideration? And is that not a question that breaks your reliance on any estoppel later on?
On the contrary, Your Excellencies, we submit that because this condition was considered and this was not reflected in the final draft of the AAA, it was safe for us to assume that this reason is not going to be taken into account in enunciating the decision of the Council finally in deciding the approval of the membership application, and therefore they are now stopped from including this reason as a denial of ADERA's membership. Furthermore, the presence of the Rotian Union Commission in Adarea, they could have very well known
I
that
put it to you that the other side will soon argue that they had discretion there, and that, among other things, the paragraph in the preamble, which refers to respect for human rights and minorities, was a legitimate reason to use this discretion at the decisive moment, seeing what your country had made of the implementation of the conditions that were put in front of them for accession.
we submit that the very fact that it's mentioned in the preamble does not mean that this was an onerous condition on part of Adarea, because Adarea was joining a union where it was expecting benefits from joining the union, and it could have together adopted a program to salvage the Sofian population. However, to come back now and be silent on 4 long years, and to come back now and deny Adarea membership into the Rotian Union because of this very reason, we submit it's a clear lack of good faith, and therefore it's a breach of the international legal obligation owed to Adarea.
But is it not quite clear from the language of Article 11 of the Russian Union Treaty that it is entirely up to the Council, and therefore whatever takes place inside is an internal matter of the Union?
Indeed, there is a discretion on the part of the Council. However, that discretion is not unlimited, and they cannot deny Adarea membership on a reason that they did not consider. Therefore, this discretion also forms a part of the international legal obligation, which is to be exercised in good faith. And because it is not exercised in good faith, they have breached the international legal obligation owed to Adarea. Now, I shall quickly move on to the point on expropriation, which is the second half of my argument. We submit that the National Industry Act does not constitute an illegal expropriation under international law. We submit 2 propositions regarding that. First of all, the provisions of the National Industry Act relate to the Adarian companies, and it is not foreign property. Therefore, there is no expropriation under international law. Second proposition is that in any event, the degree of interference and the type of measures do not amount to an expropriation under international law, particularly so because of the purpose and the context of the measures in question. And moving on to the first proposition.
But can you make that claim at all? I mean, your government acted to sort of limit the use that could make of these assets, if I try to put it in neutral terms. And it was clear from the facts of the case that that happened in reaction, and your president said as much, in reaction to the events following your exclusion for the moment of the membership of the Russian Union. And that he saw that as a kind of provisional indemnity for what had been done to your country. Now, haven't you sort of already taken unilateral actions? Why are you still coming before this court? And do you want us to give our benediction to these actions that you have unilaterally already taken?
Indeed, Your Excellency, there are 2 answers to the question. First of all, the claim of expropriation is brought by the respondents. They are the claimants in this case. Secondly, Your Excellency is pointing to the fact that because the decision was taken after denial of Adaria's membership, it reflects retaliation or possibly discrimination. We submit that it is not. Indeed, it follows as a consequence of denial of Adaria's membership that Adarian economy suffered huge losses, and it wanted to prevent capital flight. It wanted to prevent its assets from going out of the country, and therefore, at the least minimum it could do.
Are you saying this is a countermeasure?
No, indeed, Your Excellency, we do not submit it's a countermeasure.
What is it then? What makes this justified under international law, this action?
The public purpose behind this measure to prevent capital flight, because Adarian economy, in consideration of the fact that it was denied membership into the Russian Union, needs to be salvaged. The performance of the conditions of the AAA suffered huge blows on the Adarian economy, and we want to salvage the economy, and therefore this capital flight purpose is an important purpose.
Was there any proof of that capital flight?
Unfor-
that was imminent?
Unfortunately, the compromise does not give details about the actual losses that were suffered. However, it can be assumed that the performance of the conditions of the Adarian accession agreement, which are purely economic conditions, would have resulted into a situation where Adarian economy would have suffered, and therefore this measure was a legitimate measure.
It is true that the Prime Minister made that explanation, but is it not true that the situation had been foreseen already when privatization took place, and therefore to talk about the capital flight is not easy to justify in that context. What is your view?
Indeed. The situation that was foreseen at that time when the privatization happened was that Odeya will be joined into the Rotian Union, and therefore it will get benefits out of the membership of the Rotian Union, economic benefits and even other benefits. And therefore the assumption was that we will join the Rotian Union and benefits will be obtained and this situation will be remedied. And therefore that was the assumption at that time. However, because Odeya has been denied membership, it is not retaliation, it is a consequence of denial of Odeya's membership indeed. However, this is to prevent capital flight. We submit that on the standing point, the claim is inadmissible in the first place because these companies have Odeya nationality on the place of incorporation test, and no corporate wheel can be lifted in order to allow the nationality of state, the state of nationality of the shareholders to bring a claim for diplomatic protection, because none of the exceptions that were mentioned in the Barcelona Traction case apply here. One of the exceptions was when the respondent state is also the corporation state of nationality. However, that exception was not valid. The validity of this exception was not made in the Barcelona Traction case, and the Chamber refrained from pronouncing the validity, and none of the cases thereafter or even before Barcelona Traction can stand as an authority for that exception. Furthermore, even the ILC draft articles, Article 11B, I do say that my time has expired. If I may have 30 seconds to finish my point.
Yes.
And furthermore, this position is rounded by the consideration of Article 11B by the ILC in its draft articles on diplomatic protection in 2006, where they say that this exception, where the respondent state is also the corporation state of nationality, can only apply if the incorporation in that state was a precondition of doing business there. And therefore, we submit that in the first place, the claim is inadmissible, and therefore there is no expropriation under international law. Unless I can assist the court any further, I shall hand you over to Mr. Kazi Rashid. Thank you, Your Excellencies.
The second oralist on the applicant side may begin.
Mr. President, Your Excellencies, 3 propositions will be submitted regarding submission B, that the respondent states have no standing to make a claim. First, that there has been no internationally recognizable wrongful act, and thus the test of a legal dispute is not satisfied. Second, that any arguable wrongs have been committed against the Rotian Union and not the respondent states. And finally, that the Rotian Union cannot bring a claim in its own right, and that the respondent states cannot bring a claim on behalf of the Rotian Union. Your Excellencies, it is perhaps helpful for the court to clarify the question that in essence lies before it. Can the state stand in respect of wrongs committed against the organisation? Now, whilst the substantive argument in relation to the particular immunities that are enjoyed or are not enjoyed by Mr. Heap in the litigation, that is dealt with in terms of submission C. However, the procedural and technical aspect of the admissibility of the claim is dealt with in terms of this submission. If we turn to the first proposition, Your Excellencies, the essence of any claim before this court is that a wrong has been done. Now, the test of standing is twofold. First of all, there needs to be a legal dispute, and secondly, the particular party needs to have a legal interest in that particular dispute. This was established in both phases of the South West Africa case, and also the Northern Cameroons case, and also the nuclear test cases. In terms of this first proposition, we submit that no legal dispute exists. As explained earlier by my co-agent, the Rotian Union does not have legal personality in respect of Odeya. Now, Your Excellencies, the reparations case clearly and explicitly expressed the position of international law that a subject that has rights, that is, a person in international law, has the capacity to maintain these rights by bringing an international claim. Therefore, for internationally wrongful acts to be committed, the subject of such wrongs must be an international person. If this court accepts that the Rotian Union has no personality in respect of Odeya,
I found the arguments of your colleague not very convincing on that, and I would really like to go on to a later point. In the end, your argument, based on lots of literature also in the first instance advanced by your colleague, was that at least in the final analysis, if everything fails, the member states are liable for the damages that are caused. Then conversely, the member states must also be the beneficiaries of any monies or compensation for damages to the organization. If that were not true, where would we be? We have to be even-handed, after all.
Your Excellency, the apparent contradiction between my co-agent's argument and myself are obviously noted. However, we submit that there is a key difference between the obligations and the rights concerned in this particular case. As explained earlier by my co-agent, it was the Council of the Rotian Union that undertook the treaty, the AAA. Now, what was submitted earlier was the Council was either acting in the capacity of an agent of the Rotian Union, agent of the member states, forgive me, Your Excellencies, an agent of the member states. And so it was the member states who were in fact acting. However, the particular actions in relation to the delegation and in relation to Mr. Heap were acts of the Commission of the Rotian Union. Now, the Commission is very different to the Council.
So basically the Rotian Union doesn't exist. I mean, you have the Council, which concludes these treaties, and that entails no consequence for the Rotian Union as such, although it's an organ of the Rotian Union. You have the Commission, which does certain things, and all of a sudden, the member states are not engaged by that, and the Union also not, because it's the Commission. I mean, have you ever heard arguments like that? Is there any book on the law of international organizations that says that these organs sort of exist in a vacuum?
How, just on the same point,
Yes,
an additional question. How do you explain the fact that you, in the admission agreement, you accepted the mission? And are you saying that that mission that you accepted in very specific language of the Russian Union is nothing more than the aggregate of the member states?
No, Your Excellency. In terms of the proposition, the first proposition that there is no legal dispute, yes, we submit that there is no personality. However, in terms of this aspect of legal interest, it is conceded that if the first proposition that there is no personality, then we accept that if the court goes on the presumption that there is personality, it is a representation of the Rotian Union. If we come back to Your Excellency's question, as was explained by my co-agent in not only the Senator Lyons case itself, but also in the Bosphorus Airways case, what the European Court in those cases stated was that you have to look to the nature and purpose of the particular act. Now, certain competencies, whenever organisations are created, certain competencies are handed over to the organisation. That is when sovereignty is ceded. However, it is submitted that in the case of accession, that particular power, that particular competency...
But we come back to another point again, namely what kind of law this court is supposed to apply. And you're citing cases to us, which I admire in some respects, but I'm not sure that they are at all dispositive for this court. They are decisions of the European Court of Human Rights in a very specific treaty context. And we're supposed to apply international law here.
Of course, Your Excellency, and unfortunately the limited jurisprudence in the area relating to organisations of such type is obviously unhelpful to us in this case. However, we submit that the European Union is in effect comparable to the Rotian Union, and thus a similar procedure and a similar approach can be advocated before this court as a principle that has been applied in a similar situation. And thus we submit that in certain situations, whilst organisations have competencies in their own right, certain competencies are retained with the member states. We simply submit that in relation to accession, the member states have retained this competency, and thus any acts in relation to that are acts of the member state. However, in relation to sending a delegation, it was handed over to the Commission of the Rotian Union, who has no national identity, unlike the Council, who acts as the executive of the particular organisation. It is a competency not at all to do with the member states and what of the Rotian Union, and thus that the respondent states have no right, have no interest in this particular delegation, and do not satisfy this test of legal interest that is essential for the test of standing before this court.
Counsel, if I could return again to a theme that the Union has no international personality and it's just the member states. How do you square that with the language of the treaty established in the Union? It's true that at the beginning it says these various heads of state establish it, but that doesn't mean that that's what they're not creating themselves. They are creating an institution which then, after ratification, becomes alive on its own merits. And you have Article 3, the tasks entrusted to the Union shall be carried out by institutions such as the Council. You have references to consideration of Union legislation. How do you continue to and the High Court is the judicial branch of the Union. That's not the judicial branch of 5 states. How do you square that with your contention that it doesn't have international legal personality?
Your Excellency, first of all, we do not submit that the Rotian Union does not have personality in respect of its own states. Now, there is a clear difference between what is known as objective personality and qualified personality. It is submitted...
My only comment on
Yes,
that is when you have the bilateral agreement between the Republic of Idaria and the Council of the Union, you're dealing with union issues as governed by its statute.
Your Excellency, it is simply submitted that the Council was acting in the capacity of the Member States because of the reasons as earlier explained by my co-agent. However, it is accepted that if the Court is not willing to accept that the Rotian Union has personality, in any event, if it has personality, then even less reason that the respondent states have an interest in the particular organisation. Your Excellencies, it has been alleged by the respondents that wrongs have been done against the Rotian Union property, personnel, and its premises. The permanent legation of the Rotian Union in Idaria was established by the Rotian Union. In Article 3, for example, it states that Mr. Heat would serve as the representative of the Rotian Union. Thus, if this Court does accept that the Rotian Union does have personality, its personality is separate and distinct from the personality of the Member State, and thus only the Rotian Union has any interest in this particular claim, and not the respondent states. Your Excellency, this position of legal interest was very appropriately discussed and in a very relatively similar context in both phases of the South West Africa case and the Northern Cameroons case. Now, the position was, Your Excellencies, that it would not be enough for a party to show that there was some sort of mere transitory political interest or economic interest or social interest. There must be a legal obligation owed to that particular party which has been breached that that particular party can show a legal interest in. Now, in that case, for example, Ethiopia and Liberia were attempting to enforce obligations owed to the League of Nations and thus to its successor, the United Nations. However, the Court found that the obligations owed to the League of Nations were obligations owed to the League of Nations and not the obligations owed to the respondent states, and thus Ethiopia and Liberia had insufficient standing to enforce a claim. Your Excellency, if we simply imagine the situation...
Has international law not evolved since that time? That was 1966. We're now 40 years on. There have been enormous developments that have just been cited by my colleague on the bench here as to the development of these kinds of international organizations which are extremely autonomous from their member states, which are called supranational. And also, on the other hand, if you go on pretending that there is no legal personality vis-à-vis your country in these issues, what is this court to do? Why were we confronted with this case if the member states have not a sort of, again, residual interest in what happens to the union, if it's impossible for the union to appear here as such before the court?
Well, Your Excellency, first of all, it is submitted that some sort of residual interest is insufficient for this court. And although these cases were some time ago, this position is furthermore grounded in the Articles on State Responsibility from Articles 42 to Article 48. For example, Article 42 states that a state needs to be specially affected for it to be able to bring a claim before this court.
Counsel, why should, is that a treaty? Are there any parties to that? Why should we pay attention to it?
Well, Your Excellency, the Articles on State Responsibility, when they were in their draft state, were cited by this court more than 7 times in the Danube-Dan case, and furthermore, they have been adopted by the ILC as articles, no longer draft articles, and furthermore, Your Excellency, they've been adopted by the General Assembly. So it is submitted that the world opinion on this particular topic is relatively weighty. And so, yes, this court, it is submitted, should at least look and give some weight to these articles. And it is submitted that these simply reflected the position that was explained in the South West Africa cases and the Northern Cameroons case. Coming back to the point earlier that the Rotian Union in itself does not have no right in this case, Article 34, Your Excellency, is their one falling point. Only states may be parties to contentious proceedings. However, as this court itself stated on page 90 of the reparations case, this court is not the only judicial organ in the entire world. And in fact, this very court's jurisdiction is based on consent of both parties. If the Rotian Union would have approached Idaria and asked for some sort of arbitration or tribunal process, there is nothing in the compromise to indicate that such a procedure would not have been acceptable to both parties. So it is submitted that that very same argument, that Article 34's restrictiveness, was put forward by Ethiopia and Liberia in the South West Africa case, but all the judges rejected it and said that simply because the procedure did not allow it, it should not be sufficient to give a legal right where there was a legal right in the first place. Thus, we simply submit in terms of this this submission that if the Rotian Union has no personality, it cannot be wronged in international law. If it has personality, its personality is separate and distinct from that of its member states, and thus member states have insufficient legal interest in order to bring this claim before the court. If Your Excellencies have no further questions or clarifications regarding submission B, we can now move on to the propositions regarding submission C. Your Excellencies, it is perhaps appropriate to start with Article 3 of the AAA, which obviously would, on first glance, seem to provide some difficulties for the applicant. However, what we submit is Article 3 of the AAA is not of a sufficient normative character to create any binding obligations upon a Daria. Now, it is stated in Article 3 of the AAA that the rights and obligations and immunities and privileges of the delegation will be governed by international law. However, as this very court itself stated in the North Sea Continental Shelf case, that certain provisions of certain treaties are not of a potentially normative character in order to create any binding obligations. And this was on page 3, paragraph 72. For example, Your Excellencies, the 1992 Framework Convention on Climate Change.
Counsel.
Yes, Your Excellency.
I've read the same things on paragraph 17 of your brief, and I really wonder, if you go on like this, are you trying to tell the court that basically we have here an organization and a state, your state, that have agreed to a provision that doesn't have any meaning, any serious content? I mean, we must give meaning to provisions of an agreement.
Of course, Your Excellency, but it is submitted that the position in international law accepts that certain provisions of treaties are not of a sufficient normative character to create what the court itself called hard law. It is, in fact, a concept of soft law, which simply shows an intention, such as the 1992 Framework Convention on Climate Change, which simply showed a positive motive on behalf of the world community to improve climate change. And that's why the Kyoto Protocol was necessary to enforce these obligations in some form of hard law. So we simply submit that this provision in the AAA shows an intention that perhaps at some future date a specific treaty may be entered into which will outline the particular immunities.
Shall be governed by international law?
Yes, Your Excellency.
Not will be governed by international law.
Are you suggesting that what the language of paragraph 3 of AAA simply is a pactum de contrahendo and nothing more?
Your Excellency, that is our primary submission, yes, Your Excellency. If Your Excellency, however...
As my colleague has said, it's extremely difficult to read this language, which says quite clearly the rights, obligations, privileges, and immunities of the RU delegation shall be governed by international law. Are you suggesting that this is not creating a legal obligation of some kind?
Well, Your Excellency, the problem is very obvious that so many different organizations exist in the world today, all having a different function, all having a different purpose, all having a different nature, that it would be simply impossible to incorporate with this any definitive list of any particular immunities that organizations are to have and are to enjoy.
But that's a different question. You are talking about the specific contents of what it says. But what I'm saying is, what I'm asking you is whether that particular sentence creates a legal obligation rather than legal obligation to do certain things rather than what is called the pactum de contrahendo, namely to come to some agreement in the future, but at this stage, the promise to conclude such an agreement. Is that what you're suggesting?
That is our primary submission, Your Excellency. But if we then accept that if the court does not agree with that submission that we put before the court, we will then submit that in terms of what customary international law applies to organizations, that the particular customary international law does not apply to the Rotian Union in this particular case. Now, whilst we accept that there is customary international law that governs the immunities of organizations, we do not accept that customary international law covers the immunities of all organizations. Now, the organizations which are covered by immunities are those of a universal character and not those of a regional character. Now, this position was explained by the ILC in its 1990 report, where it was attempting to draft articles on the privileges and immunities of organizations. And very early on in this process, they accepted that it would be simply impossible to draw up a definitive list for the different regional and local organizations that existed in the world, so that any customary international law that existed in this area only applied to organizations of a universal character, such as the United Nations.
But Counsel, I'm sorry.
No,
Again, I come back to, well, in fact, does it not relate to an argument I think your co-counsel made with regard to either estoppel or fairness or reliance on statements earlier made, because this earlier statement says obligations and immunities of the RU delegation. It doesn't talk about the UN or some other universal, shall be governed by international law. Now, are you now saying you really didn't mean that and there was no international law that governs the privileges and immunities of the delegation?
Well, that is, again, our submission, Your Excellency, that it would be simply impossible. I mean, what would these provisions of and these privileges and immunities
Then why
be?
did you sign this?
Well, Your Excellency, again, we come back to the earlier statement that we stated that it shows in our submissions an intent to create some sort of particular treaty, as, for example, the WTO has, the European communities have. They've all entered into specific treaties outlining what exactly the provisions of any immunities are to be. Now, Your Excellencies, we submit that in addition to the requirement of universality of organisations before customary law can exist in respect of such organisations.
But you were referring there rather to the immunities and privileges of the organization itself, not so much to the immunities and privileges of their delegations or legations, as they're called here. To what extent is there a connection between the two?
Your Excellency, it is accepted that both are the same. Agents and representations of the organisation enjoy the same privileges and immunities that the organisation itself enjoys. This was stated in the reparations case, for example, Your Excellency.
Yeah, but a reparations case concerned a situation vis-à-vis also within the organization which was worldwide, and you were talking about organizations that are worldwide. You were distinguishing them from other organizations. That's precisely my point. The other organizations are likely to have less members, but they are likely to have more foreign affairs, so to say, and more delegation in non-member states.
Well, Your Excellency,
I'm not sure that the immunities of those organizations vis-à-vis their own members say anything about the privileges and immunities vis-à-vis third states.
Yes, Your Excellency. The position in the reparations case, though, did discuss whether the position would be any different if the particular violator of the immunities was a member state or a non-member state. And whilst the final decision was split 11-4, on that particular point, the court was unanimous, saying that if immunities are to be granted to universal organisations, they would apply to non-member states equally as to member states. Now, what we submit, though, is in terms of regional organisations such as the Rotian Union, this is not the case. And whilst it is accepted perhaps that customary international law affords immunities to within the member states themselves, no such immunities bind third parties. They are not party to any treaty, they are not party to the Rotian Union, and thus they are not required under customary international law to respect such immunities. Now, if the court does accept that certain immunities do extend to the actions of Mr. Heap and the legation, we submit a final proposition that the position in customary international law regarding international organisations is that they are to be afforded what is known as functional immunity, immunity in relation to their particular functions. Now, what we submit in relation to this proposition is that the actions of Mr. Heap were in effect ultra vires. They were outside the scope of his particular function, and therefore they are not protected under the scope of international law.
Counsel, who decides that?
Who decides whether they were outside the scope?
Yes.
Well, Your Excellency, it is submitted that this is the position of Adaria to decide.
Not the organization which gives this person the functions that he's trying to perform?
Well, Your Excellency, it
Not
is...
the head of the organization that determines when one of its agents is acting within its scope of its functional immunities or not?
Well, Your Excellency, the problem of that would then be to interfere with the sovereignty of each individual state. And whilst Adaria is happy... I believe my time has expired, Your Excellency.
Yes, you can continue on this point.
Yes, Your Excellency. Whilst Adaria is happy to respect, if customary international law assigns the organisation immunity, it is happy to accept immunities in relation to the particular function of Mr. Heap. However, there is nothing in the treaty, the AAA, which establishes the organisation, which indicates any right to interfere in the domestic politics of the particular country, and thus it is submitted that the particular actions were outside the scope of his function, they were ultra vires, and thus they are not protected by international law. If Your Excellencies have no further questions or clarifications on any of the points made, then we rest here. Thank you very much.
Thank you. Now I call the first oralist on the respondent side. Now you may begin.
Mr. President. Mr. President, Your Excellencies, my name is Baston. I appear with Ms. Murray for the respondents in this case. I will speak first for 23 minutes, Ms. Murray will speak second for 21 minutes, and we reserve 1 minute for Sir rebuttal. Your Excellencies, I will deal with the denial of Adaria's application to join the Rotian Union, and the unlawfulness of Adaria's National Industry Act, the NIA. Ms Murray will then deal with those interrelated issues of the respondent's standing to claim in respect of the RU legation in Adaria and the merits to that claim. Your Excellencies, as to the denial of Adaria's application to join the Rotian Union, the applicant has sought to attribute responsibility to the member states of the Rotian Union for the conduct of the Rotian Union Council on the basis that the Rotian Union has no separate international legal personality and the Council is merely a chamber of the member states. Your Excellencies, this is plainly incorrect, both legally and factually. First, the Rotian Union has separate international legal personality, and this is a fact which Adaria has recognised when it concluded the AAA. The test for separate international legal personality was laid down by this court in its 1949 advisory opinion on the reparations for injuries suffered. There, this court held that where an international organisation is intended to have personality, and in fact exercises functions which can only be explained by personality, then it is an international legal person. Both limbs of that test have been satisfied here. According to paragraph 6 of the agreed compromise, the founders of the Rotian Union, the respondents, intended to vest that organisation with a great deal of authority and autonomy.
Can I ask you a question?
Yes, sir.
Does that necessarily mean that member states don't have obligations under the agreements concluded by the Rotian Union?
No, not necessarily, Your Excellency. There are ways in which the respondents could bear obligations under agreements concluded by the Rotian Union. A common example where this occurs for international organisations is where the organisation enters into mixed agreements with other non-member states. The European Union commonly does so, even in the context of accession.
But to what extent is a mixed agreement comparable to the agreement that is here before us, this accession agreement?
Simply put, Your Excellency, it is not comparable.
No.
And as such, there are no direct rights or obligations for the respondents under the Adarian accession agreement. That is one...
But what does the Adarian constitution, what does the constitution of the Rotian Union say about that?
About whether or not they can bear rights or obligations? The only rights and obligations which the TRU attributes to the member states of the Rotian Union are those which are enforceable within the Rotian Union. Therefore, obligations...
And exactly, a treaty that the Rotian Union concludes, that's presumably concluded by an act of the Rotian Union organs, which is binding upon the member states according to what has been stated in the Rotian Union Treaty and in the authoritative voices that sort of accompanied the founding of the Rotian Union. Wouldn't you say then that the member states of the Rotian Union have rather direct obligations and can be responsible for anything that has gone wrong in respect of this agreement?
With respect, Your Excellency, no, we submit quite the opposite. Any obligations which arise, for example, to uphold the decisions of the organisation, are enforceable and opposable only within that organisation. They are a matter res inter alios acta, that is, a matter only between the member states of the organisation. For instance, on Your Excellency's point, Article 10.1 of the treaty establishing the Rotian Union obliges the respondents to uphold the decisions of the Council. However, Adaria is not party to that agreement. They cannot enforce the rights and the obligations under that agreement. Accordingly, any direct responsibility on the basis of the TRU cannot be attributed to the respondents by Adaria.
Nevertheless, in the draft articles which are presently being begun to be drafted, in the beginning to be drafted by the ILC on the responsibility of international organizations, it is said that some weight should be attached to the internal rules of the organization. How do you explain that?
We agree with that, Your Excellency. Weight should be attached, but only in certain circumstances. Special Rapporteur Guy, who drafted these articles, set out those examples in what he provisionally labelled Chapter 10, where the member states of any organisation direct and control the organisation, aid and assist that organisation, and other circumstances in the breach of an international obligation, then yes, in those circumstances, member states will bear direct responsibility to non-member states. However, Your Excellency, that has not occurred here. Indeed, the applicant has made no submission that the Rotian Union member states have directed and controlled or aided and assisted in the breach of an obligation by the Rotian Union. For that reason alone, there is no responsibility for the Rotian Union member states. Now, this hinges on the separate international legal personality of the Rotian Union, a fact which the applicant has contested. However, the simple entry into the AAA by Adaria is a recognition by that state of the international legal personality of the Rotian Union. Indeed, Your Excellency, the ILC was of the opinion, when it was drafting the 1986 Vienna Convention on the law of treaties between states and international organisations, that where an international organisation has treaty-making power, it must necessarily entail international legal personality. That was in the
Counsel, is that treaty in force, and why should we take it into account?
Your Excellency, the treaty is not in force. However, this court should take it into account because the seminal provisions are customary international law.
Based
How
on?
do you prove that?
We prove customary international law, Your Excellency, through widespread and virtually uniform state practice, which holds that those provisions are indeed binding upon all states.
Are you talking about this particular point, or are you talking about the convention itself? The fact that the convention has not been has not entered into force because of the lack of ratification, does it not show something else, something different from what you're saying?
With respect, Your Excellency, it does not. Indeed, the reason why there have only been 26 ratifications of that treaty is because political purposes of states when entering into that treaty and negotiating the draft have prevented them from going back to their domestic legal systems and ratifying them. However, as this court has recognised in several decisions...
Excuse me, where do you get that from?
The political reasons, Your
Yeah.
Excellency, from comments surrounding the drafting of those articles. Indeed, several states objected not to the purpose behind the 1986 Vienna Convention, but rather to the articulation of it by Special Rapporteur Paul Reuter. Indeed, it was the wording of those provisions which created the political pressure not to ratify. Your Excellencies, for those reasons we submit that the issue of separate international legal personality does not create responsibility for the member states. The Rotian Union is a separate international legal person. It bears rights and obligations. The member states are not responsible for those rights and obligations. Now, the applicant has also contended that the Rotian Union is an agent of the member states, and as such, the actions of the RU Council are attributable to it. The applicant relied on the work of the International Law Association here, and also the jurisprudence of the European Court of Justice. Neither their argument nor their authority can hold any apposite authority for this court. As regards agency, there is no presumption in international law that an international organisation will act as the agent for its member states. That was the conclusion of the International Law Association when it drafted the same report on which the applicant seeks to rely. The current work of the International Law Commission, that of Special Rapporteur Giorgio Gaia, has even concluded that the mere participation of member states in the ordinary decision-making processes of the organisation will not entail responsibility. Accordingly, on that dictum alone, Your Excellency, there is a presumption that agency is not the default situation for member states vis-à-vis their international organisations. As regards the applicant's reliance on the European Court of Justice and the jurisprudence of that court was considering a very different issue in cases such as Senator Lyons. There the issue was the ceding of competency over pre-existing international legal obligations.
Are we talking about the European Court of Justice or the European Court of Human Rights now?
The European Court of Justice, Your Excellency, on which the applicant sought to rely. That was the case which we dispute has relevance to
The
this
Senator
case.
Lyons case before the European Court of Justice?
Yes, Your Excellency.
Not in Strasbourg?
Pardon,
Not the one in Strasbourg, the Senator Lyons case in Strasbourg?
we understand that it was in the European Court of Justice, Your Excellency. And indeed, there was considering the issue of whether or not competence had been ceded by the states to the international organisation over pre-existing obligations. There is no pre-existing obligation here. All the obligations arise under the AAA, and accordingly, the member states did not even have the opportunity to cede competence over that obligation to the organisation. For that reason, the jurisprudence of the European Court is not apposite to the circumstances here. Turning then, Your Excellencies, to the applicant's submissions on good
But
faith.
would that mean that when there would really be a responsibility of the organization for any wrongdoing, if we assume that to be the case, that for the simple formalistic reason that that organization cannot appear here as such before our court, that there is not a sort of residual responsibility of the member states that this court would have need to have recourse to, if I may put it that way.
My question is along the same line, but perhaps slightly nuanced. Are you suggesting, or may I draw the conclusion from what you are saying, that the question of international responsibility, whoever that may be responsible for, is irrelevant here because it's the respondents are 5 states, and therefore you cannot bring this case against the 5 states because the responsible party could be the union. Is that the essence of your argument, and you are not really saying that the decision-making process of the union itself on this particular case exonerates the act which has been taken by the union? Am I right in understanding your position?
The international responsibility for a wrongful act has no repercussions for the member states because simply they did not commit that wrongful act. And this court should not substitute a non-responsible defendant for another responsible defendant. This relates to His Excellency's question in the sense that there is no residual responsibility where the proper processes of the organisation have been followed by the member states and they've done nothing to direct or control, aid or assist in the breach of the obligation. For those reasons, Your Excellency, we submit that there is no responsibility. However, to quickly address the issue of whether there's been a breach of good faith. Now, the applicant has submitted that member states did not consider Adaria's application for membership of the RU in good faith. However, Your Excellencies, the applicant gave no substance to the doctrine of good faith. It simply complained that it was unfair that the denial of Adaria's application was done by reference to a consideration which had already been raised by the RU Parliament. Your Excellencies, good faith, we acknowledge, applies to all obligations, including the obligation to vote on Adaria's application. That dictum was laid down by the 1948 admissions case, already cited, and is also codified in Article 26 of both the Vienna Conventions, again already cited. Now, the obligation under the AAA is for the RU Council to vote on Adaria's application. It is not for the member states to vote. Now, here the RU Council voted in good faith because it did so in accordance with the purposes and principles of the Rotian Union. In the 1948 admissions case already cited...
And the Rotian Union Treaty is something that you can oppose to Adaria?
No, Your Excellency, we do not submit that Adaria can oppose the RU Treaty.
You can oppose it.
Pardon me?
You can oppose the constitutional treaty of your organization
Upon
to-
Adaria?
yeah.
No, Your Excellency, we cannot. However, it is fundamental that we can take into consideration those fundamental purposes codified in that treaty when considering the application of a new member state. Here, a fundamental purpose in that treaty was the protection of minority rights. It is stated explicitly in the preamble and is more generally informed in Article 2 of the treaty establishing the Rotian Union.
Why should this court then sit in judgment on a question of a sort of forced accession, if I may put it that way, in here? I mean, I'm not quite sure any longer whether we have a role to play.
In this dispute, Your Excellency. We submit that you do. We seek to validate the decision which was made by the RU Council, which is that Adaria was not allowed accession to the Rotian Union because they simply did not comport with those fundamental values for our organisation.
But why should this court get embroiled in problems of the Rotian Union to such an extent?
Because the charge of bad faith has been brought against an international legal person, and we seek to repel that charge. There was no lack of good faith in the exercise of discretion.
I want to step back, please, for 1 second from your sort of position of advocate here. Why are we here?
Your Excellency, this court should resolve disputes which arise in the international community. It does so to maintain the international peace
But
and
is
security.
this not a dispute which has arisen primarily within the sort of constitutional ambit of the Rotian Union?
Yes, Your Excellency, I see the point.
Are you here not in front of the wrong court, if I may be so modest?
We respect, Your Excellency, that we are not here in front of the wrong court. Indeed, the forum which would otherwise hear disputes arising out of the TRU would be the RU High Court. However, because Adaria is not a member of the Rotian Union, it cannot bring the dispute before that forum. Now, when exercising its discretion to deny Dairy's application, we submit that it was done so in good faith because it was done in reference to the purposes and principles of that organisation. Indeed,
Me, but, perhaps I have been misunderstanding your position, but my understanding has been that your primary argument was that, in a word, the applicant is suing the wrong party. And that was the essence of your position. But now you're getting into the internal aspect of the program and saying that nothing wrong was done by the Rotian Union itself. First of all, is that necessary? And secondly, is that your position? And if so, how do you justify that?
Your Excellency, strictly, it is not necessary. It is posited in the alternative. Indeed, we seek to repel both arguments put to us by the applicant. First, that the member states are responsible, the subject of our first submission, and secondly, that there was a breach by the Rotian Union Council, who may or may not be the member states. We submit, of course, that it is not. So for those reasons, we make both these submissions in the alternative to repel the applicant's submissions. If we are satisfied on one of those submissions, then the case for the respondent is made out on this declaration. Your Excellencies, I turn now to the National Industry Act and the issue of expropriation. The applicant first has contested standing of the respondents to bring the claim on behalf of the Rotian Union. Pardon me, Your Excellency, on behalf of the Rotian Union investors. They argued that the property at dispute here was the Adarian companies themselves, that is, Adamois and the other privatised concerns. Your Excellencies, this is fundamentally misconceived. The property in question before this court is the rights of the RU investors as shareholders, that is, their property rights. As Barcelona Traction, the 1970 decision of this court recognised, the national state, where the national state of a shareholder cannot bring a national state of a shareholder can bring a claim on behalf of that shareholder where the respondent state is in fact the state of nationality. Here the shareholders are the RU investors and we appear on behalf of those investors. For that reason, Your Excellency, the diplomatic protection submission of the applicant cannot stand because it fundamentally misconceives the property at issue here. Secondly, the applicant has submitted that the NIA was a...
Now, there are two possibilities. Either you act here under diplomatic protection, or you act for your own harm. What is exactly the case? Because
we act in the purposes of diplomatic protection, Your Excellency. That is, we act on behalf of the RU investors. They are the shareholders in the company and it is their shareholder rights which have been negatively affected by the implementation of the NIA.
negatively affected, but has their property actually been nationalized?
It has been expropriated, Your Excellency, and we turn then to the substance of the expropriation claim. It has been expropriated.
You were just saying, and you were implicitly conceding, that their rights have been limited. And what exactly are you trying to argue?
Your Excellency,
You said the rights of our shareholders, I assume they have your nationality, have been limited.
Yes, Your Excellency.
Is that enough to decide that there's been an illegal expropriation for this court?
It can be if the extent of that interference amounts to an expropriation. Now, there is two ways in which an expropriation may occur. The first is if transfer of title occurs, the state actually takes the property, and we do not submit that has happened. The second way is if a dairy has implemented regulations which amount to a taking of property, that is, the limitation or the interference is of such an extent as to remove the effective use, control and benefit of the property. That was the standard laid down by the Starrett housing case before the Iran US Claims Tribunal in 1983. There, the effective use...
Counsel, what did they base that on?
The source of law the tribunal was applying was treaty law. The bilateral
Precisely.
Yes, Your Excellency.
And why should that apply to us here?
That treaty does not apply here. However, as jurisprudence has developed, there has developed a customary international law standard for expropriation. Starrett housing case, if you like, kicked off this standard and has most recently been codified by the ICSID tribunal in the 2005 CMS gas in Argentina.
The ICSID applies its own rules again. So what are we to... How can the ICSID codify? What is the authority of ICSID that we should recognize that this rule that was, according to you, kicked off by another tribunal suddenly poof, becomes general international law?
Not quite poof, international law, Your Excellency, but rather the tribunal in that case, having reviewed all the state practice and jurisprudence on this point, made the observation that this test had crystallised into customary international law, to use the language of the North Sea Continental Shelf case. Indeed, the rule which they said was custom was that there must be property, it must be taken, and it must be taken in unlawful circumstances. We have addressed the property.
Has the property been taken?
We submit that it has, Your Excellency.
How do you explain that?
The property has
Because
been...
there's a difference, a major difference between expropriation in the proper sense of the word and the limitation of moving the property from the country to outside. How do you say that this amounts to taking of the property?
This amounts to a taking of property because the shareholder rights have been so limited as to remove the effective use, control and benefit of those rights. Specifically, the right to receive dividends if and when declared, the right to receive a part of the liquidation upon the winding up of the company.
I'm sure you recall that in many countries, under situation of emergency, such restriction can be applied and have been applied.
Yes.
What's the difference between this case and such general measures of emergency?
Simply put, Your Excellency, there is no emergency here. In those cases, arising usually out of the pre or during war situations, there was a necessity to take that expropriation in order to take the property so the state could use it, usually for the war campaign. Here, no necessity arises. Indeed,
What is your answer to the claim by the applicant that this is a measure taken against the danger of the capital, the flight of the capital?
Your Excellency, we submit that there is no public purpose. Your Excellency, I note my time has expired. 30 seconds to answer this question.
Yes, please.
We submit that there is no public purpose here. Indeed, we submit that this is a responsive or a retaliatory measure given in response to the denial of RU membership. Indeed, even if we fall on that particular submission,
How do you prove that?
Your Excellency, we prove that by reference to other measures which have been applied by other companies in similar crisis situations. Countries such as Argentina, Malaysia and Japan applied measures, all of which were economy-wide and accompanied by other measures to dilute the situation of crisis. Even if we fall on that submission of the illegality of the taking, we rely on our written memorials to demonstrate that the taking was discriminatory, uncompensated and therefore an unlawful expropriation. Your
But
Excellency,
one last question about it. Isn't it possible to say that there was a preceding illegal act that was made good by this countermeasure?
Your Excellency, we submit that this is certainly not a countermeasure, as was recognised by this court in its 1998 Gabjakovo-Negamiros case and codified by Special Rapporteur James Crawford in his state responsibility articles. A countermeasure must be proportionate to the initial breach. That was Article 51 of the Articles, and we submit that targeting RU investors taking property in retaliation can never be a proportional response to the denial of a Darius application. Your Excellencies, I defer to Ms. Murray.
Thank you.
Your Excellencies.
I call the second oralist on the respondent's side. You may begin.
Mr. President, Your Excellencies, as Mr. Baston indicated, I will be dealing with the respondent's standing to bring a claim in respect of the immunity of the RU legation, and secondly, the merits of that claim. In relation to standing, the applicant appears to have made two key submissions. The first was that there was no legal dispute using the Northern Cameroons test, chiefly because the RU has no international legal personality and could not have been owed any obligations. In relation to that submission, Your Excellencies, I rely on the submissions of Mr. Baston, which show that the RU does have international legal personality, and Adaria did indeed accept a delegation of the RU in this case. Their second main contention on standing, Your Excellencies, was that any obligation owed was owed to the RU, and solely to the RU, and therefore the respondents could not bring the claim in this case. However, Your Excellencies, the respondents submit that even if the obligation was owed to the RU, the respondents nevertheless have standing to bring the claim in this case because, consistent with the principles of standing as found in this court's jurisprudence, the member states are bringing the claim collectively in circumstances in which it would otherwise go unheard. Your Excellencies, standing is the recognised capacity to bring a claim before the court, and rules of standing are adopted by the court for itself in accordance with its statute. Now, the respondents do realise that the ordinary rule is that laid down by the court in the 1949 Reparations Advisory Opinion, which is that only the party to whom the obligation is due can bring a claim in respect of its breach. However, this is not an exclusive standard, Your Excellencies, and regard must be had to a reasonable application of the law in each case, as was noted by the court in the 1970 Barcelona Traction case. And in that case, the court pointed out that there are two fundamental principles that underlie all rules of standing. The first is the protection of defendants, that is to ensure that defendants are not subjected to multiplicitous or distinct claims. But the second is the protection of the interests of plaintiffs, that is, rules of standing should enable legitimate claims to be heard. And as the court noted in Barcelona Traction, it is necessary that the law be applied reasonably. And we see here that a strict application of the reparations rule would in fact prevent the claim from being heard, because the RU, as an international organisation, cannot appear before the court by virtue of Article 34(1) of this court statute. However, to relax the rule in this case would not open a area to multiplicitous or inconsistent claims, because all the member states of the Rotian Union are bringing this claim collectively, so that there is no risk of multiplicitous or inconsistent claims. And we draw further, Your Excellencies, on two cases before this court which have considered extensively the question of standing. The first is the 1966 second phase of the South West Africa case, as already raised by the applicant. And as the applicant pointed out, there, the standing of Ethiopia and Liberia, members of the League of Nations, was rejected by the casting vote of the President in that case, because it was found that those two members could not bring a claim on behalf of the organisation. However, a key concern of the court, of the majority in that case, was that the operation of the League and its functioning would have been, in their words, undermined and often frustrated by allowing the existence of some 40 or 50 independent exercises of invigilatory rights. Here, Your Excellencies, there is no such risk of multiplicity of claims as was going to occur in the South West Africa case, because all the member states here are bringing the claim collectively. Indeed, as Judge Koretsky, in his opinion in that case, though dissenting on a different point, did note.
May I intervene? How do you reconcile your position with the earlier statement by your colleague that the Russian Union has the international personality, and therefore, on the first point that he made, it is the Russian Union which is the party to this whole thing. Now you are saying that here, this time, the Russian Union is not the party in question. It is the amalgamation of the separate entities consisting of 5 states. Do you not see there is a contradiction between the two?
With respect, Your Excellency, there is no contradiction. And to clarify my position, it is consistent with Mr. Baston's in that we are still maintaining that the RU is an international legal person and it had the obligation of immunity of its...
How do you establish the legal right which has been infringed on the part of the member states? Because the damage, injury, if there was an injury, the injury was done to the Union rather than the member states.
Yes, Mr. President, the injury was done to the Union, but here we are asking the court to look at the rules on standing and say that those rules must be applied reasonably in this case, as was noted by the court in Barcelona Traction, and that here...
And we, with all due respect, we are just lucky because there's only 5 member states. But if there would be 27?
Yes, Your Excellency. But importantly, all the 5 member states are bringing this claim collectively and with the agreement of the Rotian Union in this case. And we say that is probably, in fact, a very rare occurrence. And in that circumstance...
Are we supposed to create sort of new jurisprudential rules, relaxation of Article 34, etc., on more or less fortuitous circumstances?
No, with respect, Your Excellency, it is not an amendment, so to speak, of Article 34(1). Article 34(1) does say that only states may be parties in contentious cases before the court, and it is states, the respondents, who are parties and are bringing this claim. However, Article 34(1) does not restrict what kind of claim can be brought. And if we look perhaps further to the Barcelona Traction case, We can see in that case, if we return to the facts of it, that in that case it was Belgium seeking to bring a claim on behalf of its nationals who were shareholders in the company Barcelona Traction. And ultimately their standing was rejected because the state of nationality of the company, Canada, was not incapable of bringing the claim, it was merely unwilling to do so. But importantly, the court noted that the rules on diplomatic protection and the standing related to those rules had to be applied reasonably, and where the company was incapable of protecting its own interests, then the court adopted the principle that the shareholders would have standing to do so, and by derivation, their state of nationality. And we say the analogy is apposite here, Your Excellencies, because the RU is incapable of protecting its own interests, and therefore the member states...
Sorry to intervene again, but you are now talking about the issue of the standing before this court. And the examples, the cases that you are citing relates to this question. But how do you prove that through the injury done to the legation of the union, the member states have suffered the injury to their legal right as against legal interest in a broader sense?
Yes, Your Excellency, there is of course an indirect interest of the member states in the wrong done to the organisation. And while we note that the standard in South West Africa in the second phase was that there must be a legal right or interest shown, we're asking the court to look to those rules of standing, that the purpose of legal right or interest is just like the rule in the reparations case. It is to ensure that the legitimate claim is heard without subjecting a defendant to multiplicitous or inconsistent claims by various parties. And as noted by the court, that was a major consideration when rejecting the standing of Ethiopia and Liberia in that case. But we seek to distinguish that case because there only 2 members of the League would bring the claim. And indeed, Judge Koretsky did note in a separate opinion, though dissenting on a different point, that had all the members of the League of Nations Council in that case brought the claim collectively, then they would have had standing to do so. And we ask the court that to look to its reparation rule and the fundamental principles that underlie all rules of standing, and to say here that the interest in allowing the claim to be heard weighs in favour of granting the respondent standing because there is no risk to the defendant on this counterclaim, Adaria, as to a multiplicitous or inconsistent claims being brought. Turning then, Your Excellencies, with the court's permission, from the question of standing to the question on the merits. Thank you. On the merits of the claim, the respondents make 2 submissions, and that is first, that the RU legation is entitled to functional immunity under customary
Do I take it, excuse me for interrupting you, do I take it that you have dropped entirely your alternative claim that the respondents have standing to sue because obligations were directly owed to them under customary international law?
Yes, Your Excellency, that was a submission in the alternative in the written memorials, but here before the court in the oral phase, we do rely on the submissions as just given. Thank you. Turning then to the question on the merits, and there are 2 submissions, that first, the RU legation is entitled to functional immunity under customary international law, and secondly, that Mr. Heap, or Ambassador Heap's conduct in this case was within the scope of that immunity. Turning to the first submission, Your Excellencies, the respondents submit that it is a rule of customary international law that international organisations and their officials are entitled to functional immunity, and that translates here into 2 particular heads of immunity. First, relating to personnel.
Counsel, do you have any universal treaty to buttress your position on that?
No, Your Excellency, there is no universal treaty governing the question, though there is a universal treaty not yet in force on the question of representation of states to international organisations. However, we are pointing to a pattern of entering into treaties which are widespread and virtually uniform in providing for 2 particular heads of immunity.
By any chance, do you know how many parties there are to the General Convention on Privileges and Immunities of the United Nations?
Yes, Your Excellency, in relation to the 1946 General Convention, there are currently 153 ratifications.
153, so that makes about 40 members of the UN that are not parties to the General Convention. Are you saying that those 40 member states are bound by the General Convention by customary law?
We are saying...
The functional immunity aspects thereof.
We are saying specifically that there are 2 heads of immunity that have formed in customary international law in this case. In relation to personnel, that they shall be immune from acts performed in their official capacity, and in relation to property and premises of the organisation, that they shall be inviolable. And that is because out of such treaties such as the General Convention and a host of other treaties relating to both universal and regional or closed organisations, contrary to the submission of the applicant on that point, in every case those two core immunities are provided, and it is this pattern of treaty provisions which constitutes widespread and consistent state practice. And this is further, for example, Your Excellencies, we can point to agreements specifically between non-member states and regional organisations, such as the 1974 agreement between Japan and the European communities, governing immunities of the delegation in that country. There is the 1981 agreement between Spain and the League of Arab States in relation to its office in Madrid.
Counsel, excuse me, how do you answer the contrario argument that the reason this appears in all of these treaties and conventions and bilateral and exchanges of letters and so on and so forth is because if it's not there, it doesn't exist? So rather than proof of customary international law, it's in fact a recognition that you have to put it into the treaty, otherwise it's not there.
Yes, Your Excellency. We say that states still do enter into treaties because it is important to clarify perhaps the periphery of the immunities and privileges, who exactly will be entitled to them, the questions, say, of administrative or technical staff, which is still in dispute as relating even to state diplomatic immunity. But when it comes to the core, Your Excellencies, the pattern is virtually uniform, that these two privileges, these are the two necessary for the independent exercise of the functions of the organisation. And this is further underscored. It is not just consistent, we say, in that respect, or convenient that states enter into those.
And who determines the function? Then I'll cease and desist. Who determines the functional nature of the acts being performed?
In relation to official capacity, Your Excellency, as noted by this court in the 1999 immunity of legal process case, that question can be determined by the Secretary-General, the head of the organisation, as to whether an act by one of its officials was in his or her official capacity. But we say here, in fact, there has been no determination of that by anyone within the RU, and in the absence of that, it would be for the court to determine whether or not Mr Heap's actions were in his official capacity. Your Excellencies, just to return quickly to the point about customary international law, this pattern of treaty provisions is not just convenient. We say it is customary international law because it is underscored by the important element of opinio juris. And we see this particularly in the statements of governments or ministers when enacting certain legislation on the question or entering into treaties, such as in 1944, the British Minister of State, when introducing the Diplomatic Privileges Extension Act, noted in the House that international organisations were entitled to immunity as a matter of international law. And furthermore, there are decisions of municipal courts granting immunities to officials of international organisations.
Do you have a more recent citation from the British legal advisor to that effect?
No, I cannot assist the court specifically with a statement of the British government in that regard, but turning perhaps to more recent municipal decisions which determine that even in the absence of a treaty, the state is governed by customary international law to grant immunities to an official. We can see even in the practice of specially affected states, such as host states of international organisations. We can see this in the decision of the District Court of Maastricht for the Netherlands in 1984, the Labour Court of Geneva in Switzerland in 1993, and the United States Court of Appeal in Mandara and World Bank in 1983.
The Maastricht case was about what? There's no international organization in Maastricht, as far as I know.
Your Excellency, that case was between Eckhart and Eurocontrol, the European Organisation for the Safety of Air Navigation,
Yes.
and there the court stated that the organisation is entitled to immunity from jurisdiction on the grounds of customary international law to the extent necessary for the fulfilment of its functions.
Yeah, but that's again a question of an organization in one of its member states. And I would like to hear some of this with respect to an organization in a non-member state, because if we look again at Article 3 of the agreement, the AAA agreement, you must admit that this last sentence is pretty vague. The rights, obligations, privileges and immunities of the RU delegation shall be governed by international law. Yeah, they shall be governed by international law, and there's a certain obligation, as the President pointed out. But what obligation, we do not really know. And you're invoking customary international law, but you haven't given us a case yet which concerns, that is authoritative, that concerns the granting of certain precise privileges and immunities from a host state to an organization of which it is not a member.
Well, for example, then, Your Excellency, to give such practice, for example, the decision of the Labour Court of Geneva in Switzerland was that of ZM and permanent delegation of the League of Arab States. And of course, Switzerland was not a member of the League of Arab States. Even so, the court said at page 647, customary international law recognises that international organisations, whether universal or regional, enjoy absolute jurisdictional immunity. And from that jurisdictional immunity must be the immunity of the officials, Your Excellency, because to impugn the officials of the organisation for their acts would be to impugn the organisation itself for its acts. And on that basis, we say, Your Excellency, from this pattern of treaty provisions, there is sufficient widespread and virtually uniform state practice that even in the absence of a treaty, that a non-member state must grant those necessary core privileges and immunities for an external mission of an international
I
organisation.
don't know that case, but I am pretty sure that that is the League of Arab States representation with the UN in Geneva. To what extent does that compare to our situation here?
Yes, Your Excellency, it was a representative of the League of Arab States to Geneva in that case, the
To
headquarters
the
of the
UN in Geneva?
Yes, Your Excellency, but even so, it was granting by Switzerland immunity to a representative of an organisation to which it was not a member, and that is the same with the Daria in this case.
Counsel, if you're claiming functional immunity obtained in this case, correct?
Yes.
For Mr. Heap, how does that work when he's being accused of criminal acts? Do you consider the fact that he was funding political parties part of his job description?
Your Excellency, an act in one's official capacity, contrary to the submission of the applicant that it depends on a question of ultra vires, an act in one's official capacity is one done within the purposes of the organisation, for the benefit of the organisation, as opposed to for one's own personal benefit.
So it was in the benefit of the organization, your organization, for this person to violate criminal law of the host state.
Your Excellency,
Is that right, or do I misunderstand?
while it may have been misguided of Ambassador Heap to act in the way he did in this case, we remind the court that immunity is indeed provided from the laws of the host state. That is, it is immunity from being prosecuted for illegal acts. And this is not the same as impunity, Your Excellencies.
Do you have any obligation under the customary law of privileges and immunities to cooperate in the interests of justice with countries whose laws have been violated? As long as the interests of the organization are not impeded, but cooperate in the interests of justice.
Your Excellency, a number of the treaties, specifically the 1946 General Convention, do include a clause that the organisation has a duty to waive the immunity where, in fact, it would otherwise impede the administration of justice, but it would not prejudice the interests of the organisation. Here, the point, Your Excellencies, is that Adaria has not approached the organisation to waive, and it does not have to waive.
But do you have to wait until they ask you, or do you have a duty as it stands?
Even if it is a duty, a positive duty to waive, Your Excellency, we say that here Mr. Heap was acting in his official capacity, and it would prejudice the interests of the organisation to allow Adaria to seize its bank records in this case, to breach the inviolability of its premises, its permanent legation in Adaria, and in that sense, there was no obligation to waive because it would prejudice the interests of the organisation. Here, Your Excellencies, Mr. Heap was giving donations to pro-RU candidates at a time when integration of Adaria was under threat, and he did so using RU resources such that it appeared on RU bank records as were seized by the Adarian Ministry of Justice, as noted at paragraph 32 of the compromis. So we see that he was acting in the interests of the organisation, for the benefit of the organisation. It was not an act in his private capacity to secure his own election or for his own monetary gain.
So you 5 member states think that's perfectly fine to advance RU interests by violating criminal law of a particular state?
No, Your Excellency. There is no evidence that he was under any direct instruction to do so. If Your Excellency's concern is this may amount to, say, an internationally wrongful act, an interference in Adaria's internal affairs sufficient to breach the customary international law prohibition on such interference, well then, Your Excellencies, the question would be the attribution of Mr. Heap's conduct back to the international organisation, and it would be the international organisation which would bear responsibility for its interference in internal affairs. But that does not change the immunity of Mr. Heap from the domestic law of Adaria, an immunity that is necessary when performing acts in his official capacity for the fulfilment of the purposes of the organisation.
You, excuse me, Counsel. You said that there are two different issues. One is a question of the immunity. The other is the question of the respect for the domestic legal order of the country where you are functioning. Now, accepting that distinction, still the question arises as to whether what he has done is within the scope of the functional immunity. That is a separate issue. And are you suggesting, I just want to get your view clear to me, are you suggesting that because he was acting in the interest of the community or the union, he has been acting within the function, within the framework of the functional immunity? Am I right in understanding that?
Yes, Your Excellency, that this was an act in his official capacity for the benefit of the organisation, not in his private capacity in this case.
So that is a criterion you apply to,
Yes,
the,
Your Excellency.
the scope of the functional immunity.
Yes, Your Excellency.
Even if that leads to possible acts contrary to the law of the host country?
Yes, Your Excellency, because as noted by this court in the 1980 Tehran hostages case, for example, mere interference in internal affairs does not result in the loss of one's immunity. The appropriate remedy in that circumstance...
Yeah, that is a case of a diplomatic immunity which is much broader. The problem is that here we are talking about the functional immunity. The question is whether that is within the functions or functional immunity.
Yes, Your Excellency, we say it is, and we say it must be interpreted broadly because it is those immunities necessary for the independent exercise of the functions of the organisation, which has no territory of its own and is dependent upon host states for that territory.
I'm afraid the time is up, so thank you.
Thank you, Your Excellencies. Yes. That concludes the submissions for the respondents.
Thank you. So now, would the applicant like to exercise its right to deliver a rebuttal? You have 5 minutes.
Your Excellencies, we reserve 3 minutes for rebuttal, and we'll finish the rebuttal in our reserved time of 3 minutes. Okay. Thank you very much, Your Excellencies. First of all, to start with, we'll make just one point on their arguments. They said that the property in question is the right to use the company's assets. However, a reading of paragraph 42D, where the claim is enlisted, is the Owada National Industry Act constitutes an illegal expropriation of Adamo and other privatized concerns under international law. Therefore, on the reading of the claim, the property is clearly the company's. If they do say that the property in question is the rights of the shareholders, we submit that firstly, the right to use the company's assets and proceeds is not a direct shareholder's right. The case of Barcelona Traction envisaged many direct rights of shareholders. For example, the right to vote at annual general meetings, the right to declare dividend, and so on. The right to use the assets and the proceeds is the company's right because the company is a separate legal entity. The reason behind this is very clear. It is to the juridical corporate personality that the rights and liabilities should attach and not to the shareholders. There have been cases where the rights of shareholders have been held to be the contractual right to use the company's assets. However, those rights come into existence because of the existence of a separate bilateral investment treaty or multilateral investment treaty between the host state and the investor state. For example, agent used the case of the Start Housing Corporation, the Iranian Claims Tribunal. Under Article 7, which defines the national of a claim settlement declaration of that particular agreement, a national of Iran or the United States, as may be, is a corporation.
Let's cut through all that. In the end, if you are a shareholder, you want to see the profit of your company maximized. That is considerably restricted by the fact that this capital may not be repatriated and used at the place where it's most effective. I remind you that the companies were immediately very strongly integrated. To what extent do your examples, your cases speak to this consideration, which is very down to earth?
We submit that, indeed, the measure or the alleged expropriation might affect the profits and therefore might affect for example, the amount of dividend that the shareholders may receive. However, the use of the assets and the proceeds is not a direct right of the shareholders, and therefore the state of nationality of the shareholders cannot exercise a claim on the basis of this direct right, because it is not a direct right. Furthermore, because of on virtue of the arguments made earlier, the corporate wheel cannot be lifted in order to attach the rights to.
Excuse me. Would you speak to what the last person has said, Mrs. Murray, about the issue of the duties of the Mr. Heap in his official function? Would you say respond to that, please?
Indeed, Your Excellency. I do say that my time has expired,
Yeah,
if I may
please.
answer a question. The purpose of the delegation is clearly enlisted in the Adera accession agreement. That was to further the diplomatic and economic integration of Adera into the Rotian Union. The purpose was not to fund political parties and to give contributions, and that was clearly a violation of the Adherent Criminal Code. In any,
Excuse me, if we look at paragraph 30 of the compromise, there is mentioned what the section of the Adarian Civil Code says. Section 171031 prohibits contributions to any political candidate by foreign business or corporate entity. To what extent is the delegation of the Rotian Union a foreign business or corporate entity?
we submit that the delegation is an entity in itself, because the actions were of Mr. Heap. Indeed, a human has to give political contributions. However, those functions were exercised on behalf of this delegation, which had its presence in that area. It had a separate entity. It does not mean international entity. It means a separate entity within the domestic sphere. Because if the delegation had a dispute, a legal dispute, it would have sued in its own right, and therefore it was a separate entity. Unless I can assist the court any further, we rest on those points. Thank you very much.
Thank you. I take it that the respondent, which has reserved 1 minute for the third rebuttal, would like to exercise that right. Please.
Your Excellencies, one point in Sir rebuttal in relation to the expropriation claim. The applicant seems to say that the property here is only Ardemois, but as Mr. Bastin indicated, the property at issue are the rights of the shareholders, those companies which purposed Ardemois and the other privatised concerns in this case. And their property interests include, as they expressly note, the value of incorporating those companies into their corporate group, the ability to repatriate funds from proceeds of sale, to repatriate the proceeds of dividends when declared. Those rights, Your Excellencies, have been affected by the NIA in such a way that it amounts to an indirect expropriation through a regulatory guise, because the effective use, control and benefit of those shareholder rights has been affected in this case. Thank you, Your Excellencies.
How
Thank
do
you.
you,
Sorry.
excuse me,
Please,
Mr. President,
please.
I would like to hear a
final
further
question.
reaction to what you said earlier. The President said very clearly, we are in a situation where such kind of measures are quite normal in order to prevent capital flight in difficult situations. How does that square with your last remarks?
Here, Your Excellencies, there is no evidence of capital flight from Madeira, and furthermore, in distinction to, say, measures undertaken in Argentina, the only measure enacted here is the National Industry Act, which is discriminatory and retaliatory and targets only RU investors, those persons who bought these companies. It does not have economy-wide measures. It does not have exchange controls, as were other measures adopted by Argentina there as a legitimate regulation of capital
Wasn't
flow.
it more or less by chance that these companies that were privatized were bought by RU investors? I mean, it is primarily the privatization which causes, and the consequence of that which sort of seems now to have influenced the government at area to trying to prevent capital flight.
Again, Your Excellency, first, there is no evidence of capital flight, and we say that it is discriminatory. If we look to the timing of the NIA, it was enacted 1 month after the refusal of Adera's accession to the Rotian Union, and it is not merely a coincidence that only RU investors were affected. This measure could have affected many companies and many sectors of the Adarian economy, but it only targeted those recently privatised concerns which had to be privatised under the Adarian accession agreement and which Adarian knew were only owned by RU investors. Thank you, Your
Thank you.
Excellencies.
Now, this concludes the oral pleadings of the final round in the present case. The judges are going to retire for deliberation to come to the judgment, and hopefully in 15 minutes or so we'll be back. I hope you are going to wait for the result with great anxiety and expectation. The court rises.
All rise. The sound of the court is now adjourned. All rise.
Please be seated. Before going into the announcement of the final result, I would like to ask my colleagues, each of us going to offer some general comments. So why don't you start first?
Well, you know my name, I guess, and my background is mainly within the European community. I have pleaded before the two courts of the community and before the WTO panels and appellate body. And I must say that, first of all, I was very much impressed already when I received them last night by the two briefs. They are very thorough. They are smartly drafted sometimes with good alternative arguments. They are correct in their reference to sources. Basically, these are model briefs that you could appear with perhaps a little more perfection before the courts that I know. I must say that although certainly the WTO appellate body and the European Court of First Instance are among the toughest as far as questioning of the parties is concerned, compared even to those courts who at least let you talk for 10 minutes, we've misbehaved. But you have both on your side reacted very admirably to that misbehavior, remained on your feet, argued standing on your feet, kept your line, and that was no mean feat. And it was really my pleasure to listen to you and to try to trip you up. And I was very disappointed when you saw a trap coming from afar and didn't step into it. So all credit to you both.
Thank you. My comment is not very far from that of my predecessor. I sit at the International Court of Justice as one of the judges. But I must confess that I have never been on the side of the applicant or the respondent to plead before the International Court of Justice. So I realize that it would be extremely hard and nerve-breaking to plead in this kind of a situation. And against that background, I must say that both teams in the final round have managed the situation admirably well. As many of you know, it's not so much, or it is not only the question of how well you are prepared and how well you argue in a general sense. But of course, judges sitting here, somewhat contrary to the real world where we at the International Court of Justice behave, three of us, and particularly my two colleagues, have been extremely aggressive. But of course, this is an important point because being aggressive, we are not trying to be aggressive in any bad sense. It is the way of testing how the person arguing the case will respond and how quickly to judge the situation and how quickly to meet the situation, producing a persuasive argument. And from that point of view, I think both teams have done very well, and I'm very happy to see that by my own eyes or felt by myself. As I said, of course, in the real world, the International Court of Justice normally does not engage in this kind of a lively exchange between the applicant, the respondent on the one side, and judges on the other side. Now, some people say that this is a good thing. Other people say this is a bad thing. I'm not going to get into that. But I have had a very interesting and instructive experience, and I'm very grateful for that.
Thank you. My name is Larry Johnson. I'm Deputy Consul at the UN. And indeed, this was a wonderful argument by both sides. Some of the issues that were raised are things that come across my desk, as it were, the international legal personality of animals or of whatever sort. Privileges, immunities, and particularly functional immunities is a very live issue in many domestic courts in the world, and including Southern District of New York. So these two issues really caught my attention, and I have to, as my colleagues, congratulate both sides, all of your teams, because it's a teamwork, for your cleverness and for your knowledge and for your courage. I didn't see anybody really step back, as it were, in spite of the frontal assaults from my brother on the far right. But congratulations, and it was a very impressive performance by both teams in thinking as lawyers on your feet. So congratulations.
Now it's my turn to make the announcement about the final result of the deliberations that we three judges have held. But before getting into that, let me, in my capacity as the president of this court, say what I said in my personal capacity, that all three of us have been very much impressed by the performance of the two teams. Quite obviously, the two teams have been supported by the members who are now sitting here, in addition to the oralists who participated in the actual delivery of the argument. Frankly speaking, we find both teams extremely good, and it was not easy to come to a final decision. With that preliminary remarks, let me make the announcement. First, I'm going to announce the best oralist among the four persons who have pleaded, who have participated in the pleadings, oral pleadings before us. The person who we agreed upon unanimously is Mr. Lucas Bastin. Next, the winning team, again by unanimity among three of us, the team which has won this championship is Team 808R.